The Laundering, Case 08, the 5-day inquest. Procedural laundering at provincial scale in the death of Samuel Uko. Before we open, the note.
This case examines the death of a named young person, Samuel Uko, who died by drowning at age 20 on May 21, 2020, after seeking mental health care at the Regina General Hospital. The case is written about the institutional response to his death. It is not written about him. Where his family has spoken publicly, they are quoted from public record sources. Crisis resources are at the foot of the page.
Open the case.
A young black man told a Regina emergency room nurse he was suicidal. Standard protocols were not executed. The inquest examined training. Samuel Uko, 20 years old, sought help at the Regina General Hospital twice on May 21, 2020. He told the screening nurse on his first visit that he was having depressing thoughts and suicidal ideation. He was diagnosed with depression and discharged with a referral. He returned hours later in crisis, brought by Regina police. He was stuck between registration and triage and was then forcibly removed by 4 security guards while shouting that he had mental issues. He drowned in Wascana Lake within the hour.
And the institutional response.
The Saskatchewan Health Authority paid his family $81,000 and admitted failure of care in a sealed civil settlement before the public inquest sat. The inquest produced 20 recommendations on training. The clinical question of why a documented disclosure of suicidality did not trigger the standard escalation cascade was not examined.
And the connection to Case 07.
Case 07 documented the federal architecture by which civilian oversight bodies process allegations of serious institutional misconduct by the military. Case 08 documents the same architecture at provincial scale, applied to a single death in a Regina hospital. The vocabulary of placement, layering, integration carries over unchanged. The substrate has shifted from oversight body to coroner's inquest. The mechanism, with consistent results, is one.
The day, May 21, 2020, reconstructed from the public record.
From the inquest testimony, the coroner's opening statement, and the Saskatchewan Health Authority's own published account. Samuel Uko was a 20-year-old football player from Abbotsford, British Columbia. He had been born in what is now South Sudan and came to Canada as a refugee with his family in 2005. He had played 1 season with the University of Saskatchewan Huskies before moving to BC. In May 2020, he was in Regina visiting his aunt.
Morning.
Between 9 and 10 in the morning, Samuel Uko is brought to the Regina General Hospital Emergency Department by his cousin. His cousin is not permitted to enter due to COVID-19 visitor restrictions. At approximately 9:45 a.m., registered nurse Scott Harrison conducts the primary assessment. In Harrison's own testimony at the inquest, Uko seemed withdrawn and had trouble making eye contact, but did not have trouble answering questions. Uko told Harrison he was having depressing thoughts and suicidal ideation. He described being stressed about not finding work during the pandemic. Between 11 and noon, Uko is diagnosed with depression, referred to a mental health clinic, and discharged. His cousin picks him up 2 to 3 hours later near Mosaic Stadium.
Evening, second visit.
At approximately 5 p.m., Uko calls 911, asking to go to hospital. Regina Police Service brings him to the Regina General Hospital a second time. On the second visit, Uko is stuck between the registration and triage stages. A security officer consulted a triage nurse and was told Uko had to be moved. A staff member is reported to have said he needed to be taken anywhere but here, referring to a chair in the registration area. Security video, later released, shows 4 security guards forcibly removing Uko from the hospital while he shouted, "No, I have mental issues," and "I need help." While inside the hospital, Uko records a Snapchat video of himself saying he needs help.
And the outcome.
Within the hour, Samuel Uko's body is found in Wascana Lake. The forensic pathologist later determines the cause of death is drowning. His family says it is suicide. Within 24 hours of his death, the Saskatchewan Health Authority classified the matter as a critical incident, its statutory designation for a serious adverse health event, including, but not limited to, the actual or potential loss of life related to a health service provided by a healthcare organization.
Standard of care. What was supposed to happen and didn't? Walk the cascade.
Depression screening in Canadian and North American clinical settings, emergency departments, primary care, mental health intake is heavily standardized. The dominant validated instrument is the Patient Health Questionnaire 9, a 9-item self-report scale that has been in clinical use since 2001 and is in the public domain. Its 9th question, the suicidality screen, asks the patient how often in the past 2 weeks they have been bothered by thoughts that they would be better off dead, or of hurting themselves in some way. A positive response on PHQ-9 question 9 triggers an established clinical escalation cascade.
The 6 steps.
Step 1. Disclosure of suicidal ideation by PHQ-9 question 9 or by direct verbal report to a clinician, documented in this case. Step 2. Administer the Columbia Suicide Severity Rating Scale, not on the public record. Step 3. Risk stratification per hospital policy, not on the public record. Step 4. If actively suicidal, 1-to-1 supervision and transfer to psychiatric assessment, not executed. Step 5. Emergency psychiatric consult, involuntary admission if indicated, not executed. Step 6. Discharge only after risk is stratified, safety plan documented, and follow-up booked, not executed.
And the cascade is not optional.
It is the documented standard of care for emergency department response to a disclosure of suicidal ideation in adult patients. It exists precisely because, across decades of clinical evidence and inquest after inquest, verbal disclosure of suicidality is treated as a high-stakes clinical event that displaces the ordinary discharge process. Samuel Uko, on the public record of inquest testimony from the screening nurse himself, satisfied the trigger event of the cascade. He verbally disclosed suicidal ideation to RN Scott Harrison during the primary assessment at his first visit. The substance of a positive PHQ-9 question 9 was clinically reported and clinically documented.
And what the public record does not show.
No Columbia Suicide Severity Rating Scale administration is in the record. No risk stratification is in the record. No 1-to-1 supervision was provided. No psychiatric consult is in the record. He was diagnosed with depression, given a referral, and discharged. The deviation from standard protocol is the question that should have been at the center of the inquest. It was not. The inquest's 20 recommendations, every one of them, addressed training, cultural awareness, staffing levels, layout, handoff procedures, and intake interview questions. None addressed the question of whether the existing standard of care escalation cascade for suicidality was executed on May 21, 2020. That question, having been settled in a sealed civil proceeding before the public inquest sat, was not on the table when the public inquest sat.
The institution's own words. What the Saskatchewan Health Authority acknowledged before the inquest sat.
The most precise documentation of what went wrong at Regina General Hospital on May 21, 2020, was produced by the Saskatchewan Health Authority itself in 3 documents predating the May 2022 coroner's inquest. Each is a public statement of institutional failure. First, July 23, 2020, 2 months after Samuel Uko's death, SHA CEO Scott Livingston issued a formal apology to the family. Quote, "Samuel was a vibrant young man who sought help from us, and we failed to provide him the timely assistance he needed. We recognize how deeply we failed him." End quote. The accompanying SHA fact summary identifies the specific institutional failures: conflicting information on the patient's identity, the process for registration of an unidentified patient was not utilized, information sharing practices with key partner organizations, the process around removal of patients and visitors. The phrase "was not utilized" is load-bearing. The SHA, in writing, in its own publication, 2 months after the death, acknowledged that an existing institutional process was not utilized. The protocol existed. It was not deviated from for absence. It was deviated from for non-application. Second, March 2021, Statement of Defense in the civil suit. The family filed a civil claim against the SHA. The SHA's Statement of Defense, filed in March 2021, contained a further admission. As reported by CBC News, quote, "The SHA admits that it failed to meet the standard of care. There was difficulty in determining Mr. Uko's identity, and that in turn caused or contributed to the failure of the SHA to provide access to Mr. Uko to obtain the additional care and assessment that he may have required." End quote. The SHA admits, in a sworn legal filing, that it failed to meet the standard of care. The SHA also disclosed in that filing that following Uko's death, health authority officials approached Uko's family and paid them $81,357 under Saskatchewan's fatal accidents legislation. Third, the father's account of the settlement. In an interview during the May 2022 inquest, Samuel Uko's father, Taban Uko, told CBC News how the SHA representatives approached the family with the offer. Quote, "They said just take this money and don't tell everybody because people are dying with coronavirus." End quote. Taban Uko told CBC the family could not consult lawyers about what taking the money would mean. The reported context: a grieving family of refugee background, approached by a public health authority during a pandemic, presented with a settlement amount urged toward confidentiality, describes a settlement reached under conditions that are difficult to characterize as arm's length. The settlement and its associated admissions of failure of care were in place by March 2021. The public inquest opened in May 2022. The question of institutional liability had been procedurally resolved before the public process to examine it convened.
The inquest. 5 days, 20 recommendations, 1 question not asked.
A Saskatchewan coroner's inquest is a statutory proceeding under the Coroner's Act 1999. Its mandate is to determine the identity of the deceased, when and where the death occurred, the manner and cause of death, and only after those determinations to issue recommendations aimed at preventing similar deaths. A coroner's jury cannot find civil or criminal liability. It cannot find institutional racism. It cannot find that a protocol was deliberately not followed. Its statutory output is recommendations. The proceeding. The inquest into the death of Samuel Uko was originally scheduled for September 2021. It was postponed, citing COVID-19 protocols, and convened on May 30th, 2022, at a Regina hotel. Inquest coroner Robert Kennedy presided. The proceeding ran 5 days, heard from approximately 24 witnesses, and concluded on June 3rd, 2022. The witness roster reflected the inquest's structural focus. Registration staff, the screening nurse from the first visit, the screening nurse from the second visit, the security guard who moved on the staff direction, the ER director, the security manager, an SHA executive, and a CMHA mental health consultant. The senior policy authors of the SHA's mental health presentation protocol were not called. The Provincial Minister of Health was not called. The Premier was not called.
The verdict.
The jury was asked to determine the manner and cause of Samuel Uko's death. The family had said it was a suicide. The jury said it was drowning from undetermined circumstances. The family accepted that finding. The cause of death framing matters because, in the language of coroner practice, undetermined circumstances is a finding that the jury could not, on the evidence before it, conclude one way or the other. A jury that had been examining the question of whether standard suicidality protocols were executed for a patient who had verbally disclosed suicidal ideation would have had a different finding available to it. The framing of undetermined closed that finding.
The recommendations.
The jury issued 20 recommendations. Cultural diversity training, including on institutionalized racism, unconscious bias, microaggressions, and de-escalation tactics. Updated mental health care training. Regular staff huddles on patient dignity. A 24/7 psychiatric nurse and a 24/7 police officer present in emergency rooms. Architectural and layout consultation. One-on-one training at the registration desk. Improved handoff process between police and hospital staff. Process to register a patient whose identity cannot be determined. Access to translation services. Family members permitted into triage.
And the structural reading.
Every recommendation is, in isolation, defensible. Each is concerned with future staff, future behavior. Not one addresses the question of why the standard of care escalation cascade was not executed on May 21st, 2020 for a patient whose chart documented a verbal disclosure of suicidal ideation. The recommendations are forward-looking by design and statute. The structural effect is that the question of what happened on May 21st, 2020 is processed into a set of training requirements directed at all future staff, retroactively distributing the failure across an undifferentiated population and forward-projecting its resolution onto training rather than examination. During the inquest, the family conveyed in a press conference that they felt re-traumatized through the inquest process. Samuel Uko's uncle, Justin Nyi, on June 3, 2022, "You don't need to be blind to see the racism component of what happened to Samuel. The jury saw it." The family's reading that the jury saw the racism is supported by the inclusion of institutionalized racism in the recommendations text. The structural reading is parallel and not in conflict. The jury saw what it could not formally find. The recommendations are a form of acknowledgement through forward projection.
The frame, placement, layering, integration. Case 01's vocabulary Case 07's architecture applied to a single death in a Regina hospital.
The procedural laundering cycle applied to the death of Samuel Uko in 3 stages.
Placement.
A clinical question placed with a coroner. The substantive question, did standard of care suicidality protocols fail because of institutional racism on the day Samuel Uko died, is placed with the Saskatchewan Coroner's Service, an inquest body whose statutory mandate is the manner and cause of death and the issuance of preventive recommendations. The mandate does not extend to findings of institutional racism, deviation from clinical protocol, or institutional liability. The placement is the first laundering step. The question now lives inside a process whose statutory terminus is forward-looking recommendations.
Layering.
Settlement first, then inquest. By the time the public inquest sat in May 2022, the Saskatchewan Health Authority had apologized publicly in July 2020, admitted failure to meet the standard of care in a sworn statement of defense in March 2021, and paid the family $81,357 under Saskatchewan's Fatal Accidents Act. The institutional liability question was procedurally resolved before the public proceeding to examine it convened. The inquest was layered on top of an already closed liability question, with witnesses selected from operational rather than policy levels, and with the inquest's statutory mandate excluding the clinical protocol question by design.
Integration.
20 training recommendations enter the record. The inquest concludes on June 3, 2022. The jury returns 20 recommendations focused entirely on future training, staffing, and process improvements. Manner and cause of death are determined as drowning from undetermined circumstances. The Saskatchewan Health Authority issues a public statement accepting the recommendations and committing to implementation. The substantive question, whether the standard suicidality cascade was deviated from on May 21, 2020, has been placed with a body that could not answer it, layered through a prior civil settlement that closed the liability question and integrated as the public's accountability record. The reputational asset is clean. This is the same architecture as Case 07 on a different substrate, on a 24-month cycle from death to closed file.
And the meta-observation.
What unites the Regina Perception Survey circuit of Case 01, the federal civilian oversight architecture of Case 07, and the provincial coroner's inquest architecture documented here, is a single structural property. Each is a closed institutional cycle that produces a usable public record. Without examining the substantive question the cycle was constituted in response to. In every case, the individual components function as designed. In every case, the aggregate output is a reputational asset that allows the institution being examined to resume operating with its public legitimacy procedurally intact. The framework is not metaphorical. It is what the cycle does, step by step.
Cross-jurisdiction. What a coroner can do and what a premier can refuse. 4 months before Samuel Uko died, Joyce Echaquan died in a Quebec hospital. The architecture's response was different. The outcome was not.
On September 28, 2020, 4 months before Samuel Uko was forcibly removed from the Regina General Hospital, Joyce Echaquan, an Atikamekw woman and a mother of 7 from the community of Manawan, died at the Centre Hospitalier de la Naudière in Joliet, Quebec. She had been admitted for stomach pain. As she lay dying, she live-streamed herself on Facebook, while nurses and an orderly called her stupid, told her she was only good for sex, and asked who was paying for her care. She died of pulmonary edema shortly afterward. Like Samuel Uko, she made an audio-visual record of herself in a Canadian hospital, telling the people who were supposed to be caring for her that she needed help. Like Samuel Uko, that record exists because the institution did not.
And the Quebec Inquest.
The Quebec coroner's inquest into Joyce Echaquan's death was conducted by coroner Jehan Kamel between May and September 2021. Coroner Kamel operated under the same kind of statutory mandate as the inquest coroner who later presided over Samuel Uko's case in Saskatchewan. Determine the manner and cause of death, issue forward-looking recommendations, do not find liability. Working inside that mandate, Coroner Kamel produced a different document. Her final report, released October 1, 2021, concluded that the racism and prejudice that Ms. Echaquan faced contributed to her death. Her top recommendation was that the government of Quebec acknowledge the existence of systemic racism within its institutions and commit to its elimination. Asked at a press conference whether Joyce Echaquan would still be alive if she were white, Coroner Kamel said, "I think so."
And what Quebec did with it.
Premier François Legault refused the recommendation. He has continued to refuse it. His position, restated repeatedly between 2021 and 2026, is that systemic racism does not exist in Quebec, that the definition the coroner used differs from his own, and that institutional misconduct toward Indigenous patients does not, in his view, constitute systemic racism unless it is organizational and directed from authority. The Quebec government has, on the same grounds, declined to accept Joyce's principle, a 16-page statement drafted by the Atikamekw community in Joyce Echaquan's name, calling for equitable access to health and social services for Indigenous people. The principle was tabled in November 2020. It has been recognized by other Canadian jurisdictions. It has not been accepted by Quebec.
And the architecture's two modes.
2 Indigenous and racialized people died in Canadian hospitals 4 months apart in 2020 after being treated as undeserving of care. 2 coroners worked within identical statutory constraints. One named what happened, and the political authority that received her report refused to act on it. The other did not name it, and the political authority received recommendations it could quietly implement. Both institutions survived intact. The Quebec case demonstrates that the statutory narrowing of the Saskatchewan inquest was discretionary within the statute. The Saskatchewan case demonstrates that even where the discretion narrows, the substantive question can be retired through training recommendations alone. The architecture has more than one escape valve and uses whichever fits the case.
And Brian Sinclair.
The third case in this pattern, chronologically the earliest, jurisdictionally separate, is the death of Brian Sinclair, who died in the waiting room of the Health Sciences Centre Emergency Department in Winnipeg in September 2008, after being ignored for 34 hours. The provincial inquest into his death, conducted 2014 to 2017, was famously narrow in scope. It declined to examine whether racism contributed to his death, despite the family's repeated calls for it to do so. The presiding judge ruled the racism question out of scope before evidence was heard.
3 provinces, 3 deaths, 3 mechanisms.
The full comparative treatment of these cases is the subject of Case 09 of the Laundering. For the structural argument of this case, what matters is the following. The Saskatchewan inquest's procedural narrowing of Samuel Uko's death into a training problem is not the result of statutory inevitability. Coroner Kamel, working under the same kind of mandate, named systemic racism. The narrowing that occurred in Regina was a choice made within the discretion the statute allows. Why that discretion was exercised differently in Saskatchewan than in Quebec is a structural question. So is why Quebec, having received the broader finding, was able to refuse it without political consequence. The architecture absorbs both moves. That is what the architecture is for.
Actors, the institutions named in this case. No individual employee is named beyond what is established in the public testimony of the inquest. The case is about the apparatus. 5 institutions are named. First,
The subject institution, the Regina General Hospital Emergency Department, Saskatchewan Health Authority, 1440 14th Avenue, Regina. One of 2 Regina hospitals operating the Regional Emergency Department network. The site of both of Samuel Uko's hospital visits on May 21, 2020. By the SHA's own subsequent classification, the location of a critical incident. Second, the governing body, the Saskatchewan Health Authority, Provincial Crown Corporation established 2017. The single provincial health authority responsible for all hospital, primary care, and mental health services in Saskatchewan. Issued the public apology on July 23, 2020. Filed the statement of defense with admission of failure to meet the standard of care in March 2021. Paid the $81,357 settlement to the Uko family under the Fatal Accidents Act. Will be responsible for implementing the inquest's 20 recommendations. Has not, on the public record, separately published a review of whether standard suicidality protocols were executed on May 21, 2020. Third, the processing body, the Saskatchewan Coroner's Service. Provincial Ministry of Justice, statutory authority under the Coroners Act, 1999. The body that conducted the public inquest. Inquest coroner Robert Kennedy presided. The service's statutory mandate excludes findings of liability, racism, or protocol deviation. Its outputs are determinations of manner and cause of death and forward-looking recommendations. Selection of witnesses, framing of recommendations, and management of family communications are at the discretion of the inquest coroner and inquest counsel. Fourth, the commissioning authority, the Government of Saskatchewan. Premier Scott Moe, Ministers of Health and Justice, 2020 to 2022. Premier Scott Moe announced in July 2020 that the Coroner's Service would conduct a public inquest into Samuel Uko's death. The provincial government, also the constituting authority of the Saskatchewan Health Authority, was the political body responsible for choosing whether the inquest would be the only public proceeding examining this matter. It declined to call a separate public inquiry, an inquest under broader terms of reference, or a Crown investigation into the conduct of the institution in its care. Fifth, the private party, the family of Samuel Uko. Joyce Guya Isa Bankando, Taban Uko, Justin Nii, and others. Refugees from South Sudan to Canada in 2005. Parents resident in Abbotsford, British Columbia, aunt in Regina. Reached a settlement with the SHA in 2020 to 2021, under conditions Taban Uko has publicly described as not arm's length. Travelled from Vancouver to Regina to attend the inquest. Spoke publicly during and after the inquest about feeling re-traumatized by the process. Has continued to call for accountability beyond the inquest's mandate, including for individuals who participated in Samwell's removal from the hospital.
Open record. An invitation to clinicians who have worked the system.
The laundering is open for correction. Some corrections require documents from inside the institution. This case rests on the structural argument that a documented disclosure of suicidal ideation triggers a standardized escalation cascade. PHQ 9 Question 9, then the Columbia Suicide Severity Rating Scale, then risk stratification, then one-to-one supervision, then psychiatric consult, then safety-planned discharge. And that the public record of the Samwell Uko inquest does not establish the execution of that cascade. The argument is structural rather than evidentiary, in part because the Saskatchewan Health Authority has not, on the public record, published the chart audit or protocol execution review that would settle the question.
The open call.
If you are a current or former Saskatchewan Health Authority clinician, intake staff member, emergency room security worker, allied health provider, or social worker, and you can speak, on the record or off, to the following questions, we would value your contribution to the record. What is the current standardized SHA protocol for emergency department response to verbal disclosure of suicidal ideation? Is the PHQ-9 administered routinely? How is its result documented? What is the cascade triggered by a positive Question 9? Has the protocol been amended since May 2020? Are the amendments documented? Submissions will be added to the public record of this case with attribution where consented and without where not. The institution being examined here has a sole source monopoly on the documents that would settle the protocol question. This is a structural feature of every case in the series. Closing that asymmetry is what an open record is for.
Close. What this case is and isn't.
This is not an accusation against any individual nurse, physician, security guard, or registration clerk who was on shift at the Regina General Hospital Emergency Department on May 21, 2020. Such accusations are the province of the College of Physicians and Surgeons of Saskatchewan, the Saskatchewan Registered Nurses Association, professional regulatory bodies, and civil and criminal courts. None of those bodies has, on the public record, taken action against any individual employee involved in Samwell Uko's care. Nothing in this case asserts that they should or should not have. The conduct of named individuals is not the subject. The subject is the architecture.
And the inquest.
A coroner's inquest, competent within its statutory mandate, presided over by a serving inquest coroner, with a jury of 6 who heard evidence over 5 days, produced a verdict and 20 recommendations. Those recommendations are good recommendations within the form of recommendations. The form of recommendations does not contain the question of why a documented disclosure of suicidal ideation did not trigger the standard escalation cascade for one patient on one day in one Regina hospital. That question was placed with a body that could not answer it after a sealed civil settlement had closed the liability question, and the resulting public record is one in which the institution has been formally examined and the question has not been answered.
And the changes since.
The Saskatchewan Health Authority has, since 2020, made multiple changes to its emergency department mental health protocols. The SHA's published statements describe these changes. The changes may be substantial. The changes may have improved the safety of every patient who has presented to a Saskatchewan emergency department with mental health symptoms in the years since. None of those facts are in dispute, and none of them are the subject of this case. The case is about how Canada's public inquiry architecture metabolizes the question of whether a specific patient was treated as a human being by the institution that received him and arrives, with consistent results, at a report on something else. Two true statements. Samuel Uko walked into a Regina hospital twice on May 21st, 2020, and said, with his own voice and his own phone camera, that he needed help. The Saskatchewan Health Authority has acknowledged it failed him. The inquest has issued recommendations. The institution has resumed operations. Whether the standard protocol for suicidality was followed has not been examined. The architecture that processed his death is in working order and is the architecture that will process the next.